Hi, this is Russ Bleemer, and it's a pleasure being back on the CPR Speaks blog and on YouTube with our cast of arbitration experts to discuss the Monday, January 25th adventure for the arbitration at the U.S. Supreme Court. I write and edit alternatives for the CPR Institute, which runs the CPR Speaks blog, and I'm joined by Angela Downs of the University of North Texas at Dallas College of Law, arbitrator advocate Richard Faulkner, also of Dallas, and Philip J. Lurie in New York, another arbitrator, attorney, advocate. I'm going to get into the weeds of what happened for a moment on Monday, the 25th, so that we can hopefully have a lighter discussion here, because that's almost what today's events require. It was pretty surprising. The morning started off mildly, but significantly, with a denial of a cert petition. There was a case that the Supreme Court had that would have decided whether the incorporation of a set of arbitration rules into a contract between two private parties is enough to indicate that the decision of whether a case is to be arbitrated is to be made by a tribunal rather than a court. So in the case, the rules that were adopted in the contract contain a rule that says the arbitrator determines jurisdiction over the case rather than the court. The case would have decided that, and it would have reviewed the U.S. Supreme Court's standard for that. That is the first options versus Kaplan case test of whether the party stated by clear and unmistakable evidence that the decision goes to the arbitrator. This is the incorporation by reference that this group has talked about here on YouTube and on CPR Speaks before. But the court declined the case at 9:30 a.m. Eastern this morning, and after they struck this case, which is called Piercing versus Domino's Pizza, it was an employment case. It had blown up into a class action matter class action included antitrust issues. The court did something that experts seem to agree today has not happened before in arbitration. The court at 10 a.m. dismissed the terms sole arbitration case, which had been argued just last month. Now, I can easily read you the whole opinion in today's Henry Schein Inc. versus Archer and White sales case, and I'm going to do it because we normally can't read a Supreme Court opinion without putting people to sleep on YouTube. The whole opinion is just a few words. The writ of certiorari is dismissed as improvidently granted, and that's it. The entire argument of more than 60 minutes last month is gone, and the case is over. So a couple of things. As noted, the court spent more than an hour on the Schein case on December 8th. While the issue was on the effect of a carve-out from arbitration for injunctions and the effect that that has on the entire delegation to arbitration, the court in its argument kept popping up with the issue of the incorporation of a rule providing that delegation. In other words, the issue the court kept talking about was the earlier Piercing versus Domino case that was rejected before the Schein decision this morning. As the court pointed out, and as this group has pointed out in a long YouTube on the arguments, the court had already declined to address the issue in Schein itself. It had accepted the carve-out issue, but it rejected an Archer and White cross petition on the incorporation issue. So back for a moment to the rejected case, Piercing versus Domino's. In it, the petitioner and the sole amicus filer, no less an authority than George Berman, who is the director of the Center for International Commercial and Investment Arbitration at Columbia Law School. And I want to add that Professor Berman is also a member of the board of CPR, which runs the CPR Speaks blog. Both Professor Berman and the petitioner had said that Piercing was a cleaner representation of this incorporation of the rules issue, much better than the Schein case because it focused only on that. Well, now both of those cases are gone, along with the division between the way the states see incorporation by reference and the federal circuit courts see incorporation by reference. For that matter, a pretty severe rejection of arbitral tribunal arbitrability determination by the Fifth Circuit in Schein also stands. The court has moved on. Rick, it washed its hands this morning of about a decade's worth of litigation. We can read those tea leaves now. That's something they don't want to bother with. So what are you telling your clients right now about putting an arbitration in their contract clause? Please interpret the court's non-interpretation for the drafter right now and confirm you've never seen anything like this before, have you, in arbitration at least?
No, I've been in the arbitration field since the 1970s, starting out in New Orleans, which is a perfect lead in to how do I describe this decision? It's as clear as a shovel full of muddy Mississippi River water. Nobody really got any great information out of this other than what was done in the language that was used in this case ought not be done in the future. More importantly, what is it really about? Why is this important? And it's very simple. In many intellectual property cases, trade secret cases, non competition, non solicitation agreements, the standard arbitration provisions start by excluding any injunction issues. Why? Because it's typically the employer or former employer that is attempting to ensure protection of its intellectual property, and they need the injunctions. So, since they draft these agreements to arbitrate, and that's the reality, the employer drafts these, then they need to be able to run to the courts, because otherwise arbitrators can issue injunctions, but then you have to go back to the court to enforce it. So they try to keep these out of arbitration to begin with. And the court was faced with a real series of problems in the sense of everybody in the circuit courts has assumed that mere reference to a set of arbitration rules is sufficient to meet the Kaplan clear and unmistakable test. And as we saw, not only in the amicus brief that Professor Berman filed in the Domino's case, but similar to the one he filed in the Schein case, and the amicus that Phil Lurie and I and Professor Downs filed, we don't believe that it was clear and unmistakable that there is a delegation of arbitrability to the arbitrators merely by a reference to rules. And also, when the court kicked the can down the road on this one, they opened up another issue which nobody had briefed before, which is the clear conflict of interest and personal self interest of arbitrators and arbitration organizations deciding issues of arbitrability, because obviously the thumb is on the scales in favor of finding arbitrability. Unfortunately, there is a devil of a lot of money in the sense of arbitration fees and filing fees at stake. And frankly, these matters should be heard by the courts. But what I am looking at telling clients is redraft your clauses, use the language I originally used that became the Jackson v. Rent-A-Center case, say who gets to decide arbitrability, say it clearly, unmistakably, in ways that no one can misunderstand, and don't put your client back into a 10-year odyssey in the federal courts, because at the end of all of this, you know what they said in so many words? Start over from scratch. That's never what you want to tell a client after 10 years of 2 trips to the appellate court and 2 trips to the US Supreme Court. Congratulations, you get to start all over again.
Well, in that sense, it is a different case now. I want to tell people watching on CPR Speaks, we'll put a link into the earlier discussion that the group has had about the brief that they had worked on in the court and some of these other issues. Concerning drafting, Professor Downs, I know you have some thoughts you want to get out there on it. Refresh my memory. Wasn't there somewhere along the line, one line in somebody's brief, Archer and White's, or in one of the circuit court decisions that said if they had just said the one sentence that delegating the decision on arbitrability to the arbitrator, that would have been the end of it, and then the Archer and White wouldn't have had that argument?
Absolutely. Absolutely. And it comes down to drafting. And, I'm definitely building on what Rick has just shared with us. Um, as where do we go from here? What do we tell clients? What do we tell folks who are working in arbitration? It really comes down to drafting. And if the line that you just quoted, Russ, if that line had been clearly written, we would not be in this situation. And this client would not have spent 10 years and then being told to go back to the start. with no clear definition of what the arbitration means. So I think you've got to work with your clients and to be clear, clearly define what arbitration means, clearly define the roles, and really delegate what those duties. Because if not, you're spending time and money, and has been a very expensive proposition for this client, and still it's just being sent back down the road. So this is a case that we're going to be looking at, particularly from an academic standpoint, as we're working with the next generation of lawyers to ensure that they understand the importance of drafting. Certainly, the students that I work with in our clinical program will be well versed in Schein, because one of the things that you're wanting to make students practice ready, but you still want to give them the reality of being cost effective for your client. And so I think this case is a very good example of really marrying those two things, and really shining a light on the importance of ensuring that you're doing the best work that you can do for your
Russ, if
clients.
I can add something, because I
Yeah, sure. I
practice.
was just going to say, Professor Downs makes me feel a lot better about all of us devoting as much time and all and putting as much out there as we have on it, because it is a matter of a line or two here and there. And are we just plain overhyping something just because it's been at the Supreme Court? Well, if it turns into a case study and people are learning from it, that's great. I'm sorry, Rick, what were you going to add?
That's okay. I was going to say, remember that you have a trial court in the Eastern District of Texas that is famous for its rocket docket. I practice in that court. I've been a mediator and a special master in that court. If this case had stayed on the docket of Judge Gilstrap, it would have been tried about 8 years ago, maybe even 9 years ago, at far less expense, and obviously avoiding 8 or 9 years of trips to the appellate courts and the Supreme Court. And so, cost effective, it would have been infinitely more cost effective to have just tried this case in the federal district court.
Well, Schein may
Absolutely.
be facing a successor issue here that they may have to litigate as well. It looks like that's going to be part of it, as to whether or not they can invoke the arbitration contract, because Schein did not sign this arbitration contract. That was Danaher, the prior company. I'm sorry, Professor Downs?
Okay, and thank you, Russ, for that. Um, I was just thinking, the reason that we have arbitration clauses and that we are proponents of arbitration is to ensure that sides are heard, that we have cost effectiveness. And in the end, this case really turns that issue on its head, because it's one that's been litigated for so many years, and then it's actually going back to where it started from.
Speaking of litigation, and moving from the original Judge Gilstrap in Texas and the Texas view, Phil, here in New York, you were saying earlier before we went on that this case, it's not going to be at the Supreme Court anytime soon. One thing that I think is crystal clear is that they rejected the framing of the incorporation by reference. They argued about it last month and decided not to decide. It's not going to be back at the Supreme Court, but you were saying that it needs to be reframed and will continue to be litigated at the circuit courts.
Yeah, I think that's absolutely right. And in particular, in cases that present the issue that we had in Schein, where you have a carve-out provision and you need to interpret that in accordance, with respect to the incorporation of the AAA rules. I think that this, and that's certainly, I have a case myself, which is where this issue will probably be litigated. And, as Rick and Angela were saying, that many other arbitration agreements have this kind of strange interplay. And of course, the answer is good drafting, as everybody has said. I mean, unfortunately, I look back at this case and you look at 10 years of litigation and all that, and it's really a low point, I think, for the efficacy and efficiency of Federal Arbitration Act litigation. Put aside arbitration, the two are obviously related, but this is a one sentence that was in dispute, one sentence. And here is where we are. We're nowhere, basically, except maybe we've got the idea that the Supreme Court doesn't want to deal with these cases. I think going forward, people are, gonna, I think you need to take a second look at how these incorporation by reference cases are being litigated. I mean, there are issues of interest in the outcome on the part of arbitrators who decide both the arbitrability issue and the merits. We've talked about those in other presentations. There are certainly textual arguments to be made, but I haven't seen much of that. And there certainly are arguments that need to be made in these cases where now Schein is basically, representative of a split in the circuits. The Second Circuit and the Fifth Circuit will interpret arbitration agreements in that way, but there are other circuits that don't. And the issue is certainly up for grabs, although I don't think the Supreme Court is likely to want to address it or will ever address it in the near future.
Phil, I want to put you on the spot. If you were addressing the case study for Professor Downs' class, would you, instead of looking at the circuit split, would you look at the Schein, the Archer and White sales in Schein setting of two big companies, two commercial entities, versus Pearson versus Domino's Pizza, which spoke to, by its own terms, consumer and employment? Can the bridge for incorporation by reference be crossed and be used as something that's reliable in contracts in both the commercial and in the consumer employment settings?
Well, I'm very skeptical about its use in the employment and consumer setting, simply because we all know that most sane people don't go and, first of all, most of them don't even know they're signing and agreeing to arbitrate in the first place. But even if they do, I mean, they're not going back and they're certainly not looking at rules and thinking of arcane issues about who's going to decide arbitrability. But the truth is, down the road, these are very important issues. And they, yeah.
I'm sorry.
Oh, no, go ahead. You go ahead.
No, I was just going to ask Professor Downs if she also wanted to start writing her curriculum tonight at the case studies and see, would you distinguish between the two? Would you just write off consumer and employment and just focus on the commercial? How would you look at this down the road?
I think that you can, because the consumer piece, it's one that I think touches so many more folks, consumer and employment, because as Phil just shared, most of your employment, when you sign go on with a company, you actually are signing some kind of arbitration agreement, although you're not reading it, you're not understanding the the nuances and the particulars of that agreement. So I don't think that you can. I think that you've got to educate, and one of the things that we're looking to do is to really educate consumers. And so Rick is going to help us kind of do that, because we know, since we have no clear decision in Schein, we've got some fallout that we think potentially may happen with consumers and employment. So education, I think, is a really big piece for folks, because your average citizen doesn't understand what these things mean. They don't know what they're signing. They're signing something thinking that it's something that will never, ever come into play. And boy, they get a rude awakening when it does.
That's for sure. And can I add something, Ross? And you have to look at this big commercial case in sort of a different strategic light. Now we've said that 10 years were wasted and everything, but remember, the person, one of the parties, I think it was Schein, was arguing against the court determining the arbitrability issue, and the arbitrability issue was quite straightforward. It was was this an injunction action, and if so, it goes to court. If not, it goes to arbitration. Now, the other side argued for that it be decided in arbitration, and that's really what caused all the delay. And certainly the choice of you you have to look at some of the tactical implications of this too. I mean, obviously that party thought they'd be better off on arbitration on the issue and really trying to avoid court. So this was 10 years wasting that. Now that party who is going to finally be going back to court is maybe not looking back at the last 10 years like this was a waste of time, because they may have really put themselves in a good settlement position. I don't know the details. It could be the other way, but these things kind of shake out differently when you're dealing with two sophisticated entities, one of whom has really managed to avoid there being any decision on the merits for a long time. Something to think about.
Yeah, Rick, if you want to tie the going forward together, feel free.
I was going to say something that we haven't talked about, which is with the Supreme Court kicking this can down the road, that leaves the states free to reach independent, well-reasoned decisions regarding these issues. Because remember, the Federal Arbitration Act is unique in the sense that for domestic arbitrations, there is no jurisdiction clause in the FAA. That is not true for the New York Convention's, Section 200 or the Panama Convention, Section 300. But most of these arbitration decisions are actually made in the state district and appellate courts. Consequently, you have cases like the Doe versus Airbnb case in Florida, where a state appellate court is going, wait a second, we're not buying into this incorporation by reference. And if there's one really major benefit of Schein, Domino's, et cetera, it is that lawyers now should see this is a really important issue. And if the arbitration language is not carefully crafted and addresses properly arbitrability, that's an opportunity and an avenue for getting back in court, and particularly for small business, medium-sized business, where arbitration is simply not affordable and could cost an entire year's profits. They have very good reason to want to stay in their domestic state district courts. And so consumers, employees, small and medium-sized business may not be that enamored of going to arbitration, and these decisions may give them the ammunition to make clear, cogent, and persuasive arguments to their state trial judges of, hey, wait a second, you need to decide this. And the state courts have historically been far more receptive to arguments that there was never an agreement to arbitrate, that the agreements are substantively unconscionable. And, this may actually end up being a really important set of non-decision decisions, because it opens a lot of doors for creative lawyering.
Yep. Fight's not over yet.
No, to the extent it will hone the arbitration tool, it's going to make arbitration more effective, which is one thing that CPR is always been focused on, best practices. What this case is illustrative of, and will continue to be in the student case study examples, is of not being a well-honed best practice at all. But out of that, we can build something, hopefully. I really appreciate you jumping on just hours after these two non-decision decisions and making it clear for our audience. I hope we'll return with something we can dig our teeth into again soon. But thank you all very much.
Thank you, Russ.
Thanks for having.
Thanks.
Yep.
Thanks.
Thanks, everyone.